Good afternoon, everyone. Today, I have the pleasure of hosting yet another one of the PICRA webinar series for February 2021, designed to further educate our members and provide an opportunity to learn about new topics and expand our professional circle. Before we start this session, I'd like to introduce our organization briefly and our host for today. PICRA, Professional Iranian Canadian Real Estate Association, founded to facilitate and promote cooperation and networking among Iranian Canadian real estate professionals and to advance their professional career. To achieve that, PICRA relies on its members' diverse set of skills, experience, and resources. PICRA's objectives, amongst a few of them, I like to name three: provide ongoing professional development, to encourage cooperation and friendship amongst its members, and to assist in experience and knowledge sharing. A big part of this movement is to basically have webinars for our members where they can access resources and ask questions. Today, I'd like to introduce our host, Natalka Falcomer, and I like to briefly go over her long list of credentials, and if I would like to start with her firm. She found a firm called Groundworks, and I like to quickly go over her brief introduction. Natalka is deeply entrenched in real estate realm with experience in law, sales, corporate development, and management. Natalka is the founder of a commercial leasing law firm, as I named Groundworks, an executive of a luxury brokerage. She was named in Canada's top 100 elite women in real estate by the Real Estate Professional magazine in 2016, 17, and 19. Natalka is a board member of the Real Estate Professional, a board member of NAR Reach, an incubator for real estate startups, a board member of Ontario Trillium Foundation, a national director of the Real Estate Institute of Canada, and an advisor to the province's Job Recovery Task Force. She's also winner of multiple awards such as REIC Education Award, the Bentel Kennedy Literary Award, the Patrick J. Harvey Memorial Award, and the Quadrier Literary Award, amongst many. Due to her monthly publications in Real Estate magazine and successful stint in TV and her technical knowledge, she's sought after for public speaking and in national events such as Real Leasing, Springfest, ORIA Conference, and the Real Estate Forum. We have the pleasure of having her with us today, and she's going to discuss the topic of how Bill 184 and the eviction ban changed the residential leasing landscape. Without further delay, I would like to pass the mic to Natalka and let her explain and go through her presentation. Thank you so much for accepting our invitation. The floor is yours.
Thank you so much, Raj. Now that's a mouthful. And before I get into Bill 184, dubbed the eviction bill, which it's not, I do have to say one thing that's very important about me. I'm actually half Ukrainian, and anyone who knows their history from Ukraine knows that our historical roots and our bloodline comes from the Iranian Persian community. So I'm kind of Iranian too. So I thought
I'd welcome that.
I'm a close cousin. So the reason why we are talking about Bill 184 today, it is because it has completely changed really important things that we do in the real estate community when it comes to residential tenants. So let's go over what those things are. This is a long list, so bear with me. First, we're going to talk about compensation for terminating a tenancy on behalf of a purchaser. Why is this important? This happens a lot if you are buying and selling in the residential space. This change means money out of your pocket. And if you don't do it properly, guess what? It means big, big, big fines. We're going to talk about compensation now for terminating a tenancy. If you want to rebuild the place, some surprising changes happening there as well. We're going to talk about affidavit requirements. This is new. This is brand new. And in fact, there's no real standard document that they've put together, they being the landlord and tenant board, for this particular requirement. We're going to talk a little bit about that. Finally, your past will be considered. This is something that is brand new as well. If you have a history of doing renovictions or moving every 2 years and kicking out a tenant, that history may come back to bite you, and we'll talk about why. Next, the penalties. My word, the penalties are huge now. The penalties are huge for anything that you do in violation of the Residential Tenancies Act. And there are surprising things that we all do on almost a weekly basis when we interact with tenants that can lead to such massive, almost bankrupting level penalties. Next, we're going to talk about rent increases and rent freezes. What's happening in the context of COVID-19 and what has changed with respect to rent increases, and also whether or not a tenant can come back to you if you made an incorrect rent increase. Spoiler alert, this was possible years ago, and I would see tenants coming after landlords for thousands of dollars for an incorrectly given rent increase and winning. Things have changed in that space. Next, we're going to talk about tenant evictions and COVID-19 bans, what that really means. And then finally, we're going to talk about this whole thing called fast-tracked evictions. This is all covered under Bill 184. We have a lot to talk about here, but why is this so important? It's so important because guess what? Tenants know what these rules are. And I am now seeing more and more tenants going after landlords for even the slightest of inconsistencies with the Residential Tenancies Act. And if you are even slightly offside because compensation costs against you are now doubled than what it used to be, this costs you a lot of money. So let's talk about new compensation requirements. What is this about? This is about situations in which you're a seller, for example, and a purchaser wants to have their property free because they want to have, not free, but rather free of a tenant. It'd be nice free, especially with today's prices, but free of any tenant because they want to move into it. Well, what does that mean for you? In the past, we've always, as landlords that are selling our product or selling our residential unit, we have already been in situations where a tenant says, I'm not going anywhere, pay me. So that used to be the informal world. Now it's formalized. So essentially, if you want a tenant to leave because you are selling a property, you have to give them equal to 1 month's rent. Other options are, instead of the money, you can offer the tenant another rental unit acceptable to the tenant at another property of yours, and so on and so forth. Acceptable to the tenant, that's a big barrier. That's undefined and difficult to do. You're likely better off giving them something that's equivalent to 1 month's rent. Interestingly, however, in the general market, I'm seeing that landlords have to give way more than that to get tenants to move. And I think it's going to get even more difficult because of rent rates going up once we open up our doors for immigration and so on and so forth. So right now, tenants are a little bit more willing because rent rates have dropped and they sometimes can get a better deal elsewhere to get out. But let me tell you, it's going to get more difficult going forward. And you're likely going to have to pay more, even though the Residential Tenancies Act doesn't require that. One caveat. What has not changed is as follows. The N12, which you would be serving in this instance, requires that you still give 60 days notice to the tenant. Here's another caveat. If it's a term lease, so let's say a full year, you cannot serve them an N12 if the purchaser wants to move in halfway through that year. Let me give you an example. Let's pretend you have a tenant and their lease expires February 2nd, 2022. You're selling your property and a buyer wants to move in February 2nd, 2021. Can you just give them a 60-day notice and walk away, meaning that they have to leave after 60 days? No. It has to coincide with the end of the term. Okay, that's often overlooked and a big issue, because if you don't do that, you can get yourself in a very harsh situation in which you're promising a tenant a vacant property upon close and you legally cannot deliver it. I have seen this happen, and that's a huge lawsuit to the tenant or to the landlord, and a huge lawsuit to the purchaser as well if they don't want to close. It's a mess. So make sure that you understand, how to actually serve proper notice and when you can actually evict a tenant because a purchaser is moving in. Another one. This has to do with compensation for renovations or demolition. In the past, if your building had 5 or more units, then this applied. Otherwise, it didn't. So what is this? Well, essentially, if you are you have let's say one single family home, one home, and you want to renovate that place, upgrade it, etc. In the past, you would serve them with an eviction notice and off they went, and you could renovate it, but then they'd be able to come back. Remember, they would be able to come back. Now, that really was the be-all and end-all of that process. Not anymore. If you want to remove a tenant because you want to demolish the place, you have to compensate them now equal to 3 months' rent. Alternatively, you can offer the tenant another rental unit that is acceptable to the tenant. So this is big money that now applies to you. If you, let's say, own a property, you want to renovate it and move in, 3 months' rent. It's a huge change. And you better be aware of it, because if not, you can get fined. Next is affidavit requirements. Why is this even relevant? Well, the laws are now changed. If you are on behalf of a purchaser submitting an N12, remember an N12 is saying, tenant, you got to get out because the purchaser wants to move in. Guess what happens? You have to sign an affidavit saying that within the last 2 years, or attesting to whether or not you've filed an application giving notice of termination for under section 48, 29, and 50. What are these sections? Personal use. So if you were a landlord, you had a property, you wanted to move into it, that's a section 48 application. You have to let them know. Or if you demolished something in the past, in the last 2 years, thereby kicking a tenant out, you also have to let them know, them being the landlord and tenant board. And then finally, section 50, conversion for repairs. So if you've kicked a tenant out and repaired a place in the last 2 years, you got to put that in your affidavit. Why? Because the boards are now saying, if we think you have a history of filing these applications too much, even if this is your business, by the way, your business of buying homes, flipping them, renovating them, or you legitimately want to just move into the homes that you've rented out, they can say, they being the landlord and tenant board, we're not approving any evictions. We're not approving any applications to remove a tenant because you want to sell the place and the purchaser wants to move in. That's a big problem. Imagine if you're a landlord and within the last 2 years, you have terminated under any of those sections for legitimate reasons. They're not nefarious, fraudulent, for legitimate reasons. They can turn around and kibosh your entire deal. So if you're signing agreements of purchase and sale for a tenanted property, be aware that you may have a situation in which you cannot deliver vacant possession and thereby violating the terms of that agreement in purchase and sale. So again, past history is being considered. Your application to remove a tenant can be denied. This is huge. If you are working with any buyers that have in the last 2 years moved into a place that's tenanted, done any demolitions, etc., or you're working with a landlord, same scenario, be aware that they may be in a situation in which that tenant cannot be removed. And this is where it gets really bad. I'll let these numbers sit in for a second. Individuals now can be fined $50,000. It used to be $25,000. $50,000 if they're caught giving a N12, for example, in bad faith. What does that mean? For example, let's say I buy a property, and very often there is a tenant who's paying under market rent. I want them out. Or maybe they haven't even been paying rent at all, and I want them out. Often, the fastest, easiest way is that I hear people saying this is not correct, this is illegal and will cost you money if you get caught. They'd say, well, you know what, no problem. What I'm going to do is this. I'm going to give them an N12, meaning that I intend to move into the unit, therefore they have to go. Quick and easy. Or my grandmother wants to move in, or my daughter wants to move in. And then as soon as they're out, we're going to make it nice and pretty, paint the walls, clean it up a little bit, and then we'll relist it for at market rent. Landlords used to do this. It's called a renovation, as one example. If you do that, and the tenant finds out, and they bring an application to the landlord and tenant board, that can cost you, if you're an individual, $50,000. If you're a corporation, $250,000. Let me tell you, it's not worth the couple bucks that you will earn as a result of giving something like this in bad faith. Be very careful, be very upfront, and be very honest. Because another thing that I have found, tenants watch. They watch. So if they see anything on Craigslist where they used to live within that 12-month period, because you can technically move in for 12 months, by the way, and then leave after that, and then relist it, they'll file an application. It's not worth it. You're not going to make your money back. And here's something else. If you do anything in bad faith, and that tenant therefore leaves as a result of a fraudulent application for a purchaser to move in, for example, or for renovations, for example, guess what? On top of that $50,000 or $250,000, the landlord and tenant board can also order an additional 12 months of the last rent charged to the former tenant that you have to now pay to the tenant. So let's just do the math there. Let's say it's $1,000. That's what? $10,200 that you now have to pay, plus the $250,000 or $50,000. It gets worse. They can also, they being the landlord and tenant board, order a $35,000 fee on top of the compensation to the tenant, on top of the $250,000 or $50,000, and on top of the remaining component, which is all of the tenant's expenses for moving. This could be very easily close to almost $500, let's say $750,000, if not more. If you're a corporation, be careful, be honest, be diligent, and fill out those forms properly. Because if you don't pay attention to the timelines and so on, this could be your fate. And on top of it, one last thing, just to add to the bucket, any reasonable out-of-pocket moving costs, storage costs, other expenses that the former tenant has incurred or will incur. Will incur? That's very, very broad. That means I could or could not incur it, maybe not. I don't even have to prove it. And I, as a tenant, can make sure you, the landlord, fork over that money. It's big. Now, this is the next one that really catches people. Generally, rent increases require 90 days written notice, okay? And if proper notice, so 90 days, it can't be 89 days, it can't even be 89 and a half days. It has to be at least 90 days. And in fact, and I didn't disclose this beforehand, when I was at law school, I worked at Parkdale Community Legal Services representing tenants. And let me tell you, I know every which way to make sure a tenant doesn't pay your rent increase, that a tenant can avoid getting an eviction order. We do it. There are lots of legal aid societies that help tenants do this. And one of the biggest components you have to realize is that these notification requirements, when it comes to rent increases, evictions, notice of for example, a purchaser moving in, you have to be precise with the number of days. If you're even off so much as one day, that application, that notice is deemed invalid. And then you have to wait a full other 90 days to do so. So be careful. In addition to that, make sure you get the spelling of the name perfect. If you don't, that's another reason that we can actually have any notice withdrawn or rejected. So be very cautious of the details on any of these forms that you complete. So let's go to rent increases. Generally, 90 days written notice was required. And also, you cannot increase rent since the last 12 months, right? So basically every single year. You can't do it beforehand. Now, what used to happen is if a tenant realizes in 2012, 2012, that you incorrectly gave them a notice because you were 1 day off even, guess what? They can go back and sue you for that improper increase, and then therefore every increase on top of that. Thousands of dollars are lost here. Thousands. Thankfully, Bill 184 has changed this. Essentially what they have said is even if it's incorrect and the tenant continues to pay for full 12 months without complaining and without filing an application of the board, let's say 5 years down the road, they realize that you were 1 day off with your application or you asked for an increase that was above guideline, guess what? Actually, sorry, just for a proper notice, not above guideline. Guess what? They can't come after you. That's fantastic news. Big warning. Right now, there's a rent freeze. Okay, so it was passed a couple of months ago. I think around October is when the limit happened. We don't know when this rent freeze will be lifted. There's still no clarity on that. But essentially what this rent freeze says is that no rent increases are permitted in 2021. Here are a few exceptions. You can increase rent for 2021 if you received an order from the board confirming that increase prior to October 1st, 2020. Not that you gave a notice to the tenant, but that the board ordered and approved an increase. What scenarios would apply for that? Well, for example, if you did a big capital expenditure, you had to repair the roof, for example, or if you provided additional services to the tenant, then that would be a reason for you to apply to the landlord and tenant board and then get an order saying that that above guideline increase or that general increase is permitted. So again, it's not if you give a notice to the tenant before October 1st, 2020, but rather if the board confirmed and approved that particular rent increase. Now, a lot of you are going to say, well, Natalka, rent regulations and increases, so there's the notice requirement, but now the increase requirement, i.e. the cap, that doesn't apply to anything that's been built after November 1st, 2018. True. However, guess what? Ban still exists for even those properties. So if you own a property that falls outside of the rent guideline increase exemption or requirement, i.e. it's exempt from those small increases, it doesn't matter. Right now, there's still a ban. Here's something else that has changed that I think is very good. Back in the day when I'd wear my tenant hat and represent tenants, a way that we can persuade the board to not evict a tenant, even if they haven't paid rent or have been in non-payment or arrears for months, is if we raise a Section 83, i.e. a tenant application. How? We'd say, board, the reason why our tenant hasn't been paying is because the roof needs repair, there's not enough heating, the floors need repair, so on and so forth. 9 times out of 10, because you didn't actually have to tell or even bring evidence to the board of it, the landlord's caught off guard. And the landlord would say, but they never notified me. And the landlord and tenant board, depending on who the board member was, would say, we don't care. It's legitimate enough to us. We're not granting the application for eviction. Too bad, so sad. No longer so. Now it's fair. How's it fair? Well, now the landlord has to provide adequate notice to you, the landlord, and to the board with respect to their intent to raise an application of such nature. If they don't, they also have to have a reasonable explanation for doing so. This really is just more fair. Now, this is something that also happened pursuant to the Bill 184, and it has to do with giving the board the power to consider if a landlord has made an effort to negotiate an agreement for rent arrears. What is this? Well, essentially, Bill 184 created one small provision and one small caveat. This, by the way, is going to be repealed as soon as COVID-19 is over, but it applies now. Everything that you do with your tenants, make sure you document negotiations and you behave fairly. Why? Because once these eviction bans are lifted, and we'll talk a little bit about what that eviction ban actually looks like in a moment. Once that happens, and the boards will file and hear all of the applications, they're going to look at whether or not you are actually fair and reasonable, meaning that you tried to provide deferrals, you tried to provide extensions, maybe even rent reductions. Work in good faith. Now, let me tell you, even if this section is going to be repealed after COVID-19 is over, hopefully soon, here's a reality. And the reality is as follows. Landlord and tenant board members, i.e. the people that decide whether or not to hear your application, they're human. And what I've noticed is that if you act fairly in any situation, the board will look at you favorably. It's also just a good thing to do, but the board will look at you favorably and likely make a decision in your favor. Always be fair and document, document, and document. Even if you have a verbal discussion, for example, with the tenant and you guys just go back and forth as to a potential solution, write it down on a piece of paper, date it, and put the time. Mark down who was present. Mark down what was discussed. The reason why this is so important is because the boards basically look at you guys and say, who's more credible? If you've documented everything and it shows the conversation, or you've documented everything and you can refresh your memory, that increases your credibility and the likelihood that the board will agree with your decision. And it also avoids misunderstanding between you and the tenant, as well as an unsavory tenant lying at the board. One other thing that we should note about tenant evictions right now, which is incorrect, a lot of people are talking about the eviction ban right now. So that does not mean that the board is not hearing applications. And it doesn't mean that you shouldn't be giving tenants who are late in rent or what have you, eviction notices or notices to pay rent before filing at the board. The board is still accepting applications. They're still scheduling hearings as well, virtually, of course. The only ban is on enforcing those orders. So if you have a lot of tenants who are causing damage to the property, you've tried to negotiate with them to pay rent, they're just completely delinquent, so on and so forth, don't hesitate. Get those notices in now, follow the proper procedures, get it filed at the landlord and tenant board, get your hearing, because the second that this is over and this ban is lifted, let me tell you, the board is going to be flooded. You'll be even further delayed. You want to make sure you have that in your hand so you can press go the second that the eviction bans are lifted. So again, big mistake. People think that the board is not hearing applications. They are. And in certain circumstances, for example, if there's damage or violence that's happening at the property or any illegal activity, you can still evict a tenant. So this whole eviction ban is not accurate. Finally, applications for landlord compensation. Who would have thought this is something that we'd ever live to see the day? So essentially, in the past, landlords could not get compensation from a past tenant at that particular location. So let's say you own a property, you have a tenant who's in arrears. You go to the landlord and tenant board. You finally get an order saying that the tenant owes you money and the tenant can be evicted. Well, here's the problem. The second the tenant leaves that property and your relationship of landlord and tenant is severed, the landlord and tenant board no longer has any jurisdiction to hear your matter. You then have to go to court, get another court order, sue them, file the application. It's a process. It could be years before you're actually able to get an order from the court to say, tenant, you owe me money, you have to pay, or that you can sue them. You have to go to small claims if it's still a small claims matter to sue them. What a disaster. What a disaster. A tenant effectively then can just get away with not paying rent, leave, and there's nothing else really a landlord can do. Not so anymore. Now, you as a landlord can go to the Landlord and Tenant Board and get an order for arrears to be paid back, even if the tenant no longer is in that space. Caveat, you only have 12 months, so act quickly. Next is compensation for interference with reasonable enjoyment or another lawful right. When does this come up? I've actually seen some good case law on this. If, for example, a landlord lives at the top unit, tenant at the bottom unit, the tenant is doing illegal activity, there's violence, like quite a material, the standard's high impact. Another situation in which a landlord can not be able to have reasonable enjoyment of their properties if they want to move in and the tenant refuses to, despite proper notice and all that fun stuff. Or if, for example, a tenant is refusing to allow the landlord the ability to show the property for the purposes of selling that property. Guess what? Finally, the board will compensate the landlord for any such interference against the tenant. Now, here's the caveat. Let's see how much that really is. There's no minimum and there's no maximum. So it could be $10 for all we know. And if in fact you find yourself in this situation, you have to document your losses. You can't just make up a number and say, I was inconvenienced, mental strain. You actually have to show loss. So make sure that if you're looking or if you're thinking about using this as a way to be reimbursed by a tenant who legitimately is interfering with your use of the property, be sure to document exactly the nature of those costs. So for example, if you can't get the property sold, estimated costs with respect to that, marketing the property, all those type of things, and maybe even the loss of the value as well if the market declines as a result of the tenant during a time in which you're trying to sell and the tenant's just not cooperating. Another thing too, which is massive, this is a massive coup, is for tenants who fail to pay utility costs while they're in possession. So, or after 1 year after the tenancy ceases. Why is this important? I've had this happen so often to even dear friends of mine who are landlords, good people who are renting out a space to a tenant. The tenant is supposed to be paying utilities. They don't. Guess what happens? The utility companies don't go after the tenant. They go straight to the landlord. The landlord's on the hook. The landlord sometimes, and I've seen this, has to pay tens and thousands of dollars because the utility didn't, tenant didn't care to pay for it. And guess what? Because of how the laws are, landlord has to pay it. And they couldn't, under previous legislation, go after the tenant for the money that is owed to me, the landlord, for the very thing that they used. It's infuriating. Finally, this has changed so that you can actually pursue the tenant at the Landlord and Tenant Board. Finally, certificate of service. What is this? This is a certificate that is now required for certain notices underneath the Residential Tenancies Act. For example, certificate of notice if you plan to demolish, etc. What is this? This is basically a certificate saying, I, landlord, swear, or my representative swears, I handed the notice to the tenant, I mailed the notice to the tenant by registered mail, etc. This is basically saying, look, I swear I gave it to them and I swear that they got the notice. Why do you have to complete this? And I would do this in any instance you're providing a notice to a tenant, because very often the Landlord and Tenant Board, a way to get out of an application or a potential eviction is say, I didn't get the notice. Even if you did, I didn't get the notice. And the landlord's going, well, I handed it to you. I don't remember that. A way around it is having a certificate of service. Of course, it has to be true. So make sure that you always complete these every time you give a notice, even if you think you're going to work out with the tenant, doesn't matter. Give this, complete this. The certificate of service is available on the Landlord and Tenant Board site as well under the forms section if you scroll down to the very bottom. We're almost over. We're almost done. We have 2 more slides. Now, this is where the media is saying expedited evictions. Bill 184 creates expedited evictions. Tenants will be evicted without even any notice. Not even close. I don't know what they're talking about. So tenant advocates are saying this new Section 78 says that the board can mediate an application, and they can also order an ex parte eviction notice or eviction order without the tenant being present. So the tenant advocates are saying, this is a take it or leave it plan, meaning that the board is basically saying, we can come in and we can mediate and we can tell you what the solution is, and you got to take it or leave it, tenant. And that also now the board is able to make these eviction notices without a hearing, without the tenant even being present. Not accurate at all. First of all, let's look at what the section actually says. It basically says that the board may attempt to settle a matter through mediation. Guess what? The board always had that ability, and the board always encouraged people to mediate before they went to the board. This is like 101. This is not as if it's a take it or leave it plan. The parties have to agree. How a mediation works, it's not an arbitration, okay? It's not an order. A mediation basically means someone comes in there and tries to facilitate a solution between both parties. They still can go to a hearing to resolve it. That's not the case at all. So dispense with this notion that this is like some mandatory, board decision that's going to come down. No, they're trying to mediate. The next one is allowing under subsection 206. It basically allows the board, and this has also existed in the past. This is not a big issue, by the way, to basically issue an eviction order if the very specific following circumstances are in play. And they are as follows. Number one, you got a board order. In the board order, the tenant was supposed to do something. And in the board order, it says that the board can evict the tenant if they fail to do that particular thing or issue an order for eviction. What has to happen for that to actually come into play? The following. Tenant has to get a notice. Tenant has to fail to comply with the notice. Landlord has to file an application at the board. Landlord has to deliver a notice of application to the tenant. Tenant gets the hearing notice. Tenant shows up. Tenant and landlord mediate the situation. Tenant, by the way, also gets access to duty counsel, i.e. lawyers that sit there and help support the tenant. Landlords don't, by the way. After that happens, they have to come to an agreement, okay? The agreement then has to go in front of the board. The board has to approve the agreement. The agreement has to then say that the tenant has to do, let's say, pay rent on the first day of every single day of the month. And if the tenant fails to pay rent on the first of every day of the month, then the board can issue an ex parte order. By the way, that means that the landlord has to go back, go through the application process, and get that order from the board. This is hardly a situation in which a tenant unknowingly will wake up one day and have a sheriff knocking on their door. That's not the case at all. It's a process still. So it's not a big win for landlords. There's no fast-paced eviction as they have claimed. This is a lot of information, and I realize that. If you have any questions, feel free to email me or call me, or you can visit my website as well. We specialize in commercial and residential leasing. We do represent people at the board. We have done this for quite a many number of years. We have great relationships with those at the board as well. So if there's anything else that you need, feel free to reach out there. And now I believe we're going to open up to questions.
Well, thank you very much, Natalka, for a great presentation. It was quite educational. I think a big portion of our business has been and will be related to leasing. In our community, we have a lot of visitors, seasonal visitors, people who are coming here to start off, and often we end up on both sides of the deal. Either side of the deal. We could be representing a tenant or a landlord. It's very good to have a more in-depth understanding of that. Thank you so much. With that, people are joining through different medium, and I have a couple of questions, and I encourage our viewers to also share their questions on the comment section. But I got two questions so far. One was the N12 form that you mentioned that has to be given at least 60 days prior
Right.
to the, but it has to coincide with the end of the contract. The question is, what if it doesn't? And the person signs that form? Um, can they just simply later change their mind, or if they sign it, they're okay?
No, so they can change their mind because it's an improperly given form. The better form to give, by the way, in all circumstances is the N11. The N11 is basically this: notwithstanding the term, notwithstanding anything else, landlord and tenant agree that tenant's going to leave on XYZ day. Full stop. There are no notice requirements. There are no sort of hidden issues. It's basically both parties coming together saying, we're going to ignore everything. I'm going to go. Goodbye. So an N11 is always your best bet. And I often encourage people to do that if they're confused about the timelines, or if you know the tenant has a long term and they just can't seem to come to some other type of agreement. So that is really the best approach to use. But great question.
Excellent. One more question that actually came up was regarding a specific case. We do not try to take advantage of the situation and ask for legal advice. It's just a topic of conversation. Feel free to comment in any way, and I can ask the individual to approach directly and speak with you.
Sure.
Because I do not want to disclose the specifics. But the person is asking that they have recently placed an offer on a property that has been rented for past 17 years, and the tenants don't have a contract with the owner, but the owner has given them an N11 or 12. I think it says 12, but so I've given them an N12 form, and they said, "Don't worry, they're gonna leave on the closing date." Would they be considered tenants after 12 years, no contract? Or
oh yes,
okay.
Oh yes. So this is what's really interesting, is that very often people think, well, there's no contract, so there's no landlord-tenant relationship. Let me now confuse you. Landlord and tenant relationships don't arise out of a contract. It's called contract law. It actually also, it can, of course, but it also arises out of something called property law. And property law does not require a contract. This is how you know you have a landlord and tenant relationship, even though you have no contract. The tenant is doing something and you don't live there. So what does that doing something mean? They don't even have to be paying you. If they just take care of the property, that's good enough for there to be an exchange between the person occupying the space and the rightful landlord, the rightful owner of that space. So, for example, if a tenant just pays rent by virtue of cleaning up the place, what have you, that could be sufficient to deem that the Residential Tenancies Act applies. So contract or no contract, doesn't really matter.
Excellent. That was a great feedback. Let me check the comment section. No worries. I'm getting more on the group chat than I think people are out working and they're joining us from their cell phone. So let me just quickly check one more time. Oh, perfect. Here's another one. Basically, you mentioned they wanted to ask a question regarding when you were talking about basically the renovations that they used to do before. They say, "Oh, I want to fix the place," and then they would ask you to leave, and perhaps you don't come back because after a few months of being somewhere else, you really don't feel inclined to go back. So they just wanted to confirm that the difference is that you have to under existing rules, you have to pay them 3 months
Yes.
and to leave, or just 3 months to them and they still have the right to come back.
Yes, 3 months to leave. They don't necessarily have the right to come back. That has changed as well. Yes, but you have to pay them the 3 months. Yeah.
Excellent.
And by the way, to repair, it can't just be like some minor repairs. Like you have to like be doing something quite serious in order to say they can't even live there during those repairs occurring. So another threshold that people don't realize, it's not just painting the walls. Like you have to really do something that basically pulls them away completely, so that they have like no other option but to leave.
Yeah.
Yeah.
I actually want to read another question from the comments section, if possible. The question is, how can you trace the tenants who have damaged your property and left?
Yeah.
Because some of those in commercial, they have these midnight runs and where they just pick up and go, or if a tenant damages your property and leaves, do you have to go through the court system or still go to the board?
Yes. So if they damage your property, you can now go to the landlord and tenant board. In the past, if they're no longer a tenant, you would have to actually go to let's say it's a small claims, to whatever court level. Let's say it's a small claims court. Now, how do you find them? This is actually a really good question. And it actually is why I strongly encourage all landlords to get the driver's license. Always get their driver's license or their passport, or something that shows that or their health card can be used as well, or information about where they work. The reason being is something called skip tracing. So first of all, anyone can do this. You don't need a court order. You can hire, most paralegals do this as well. We do this too on behalf of the landlords. We get their information, and there's a service that allows us to try and find them and comb through all banks, places of employment, et cetera, to find them again. Now, the problem, when this isn't possible, is if the landlord's like, but I don't have their driver's license, I just know their name. You're not going to have luck. We need banking information at times, can also be a solution, but mostly it's some sort of government issued ID. That way you can find them. And that can be done without a board order and all that. Now, if you want to enforce it against them, and then let's say have an order, let's say we've seen this happen as well. We've done this. We find Jay. Jay's the one that we have a board order from the landlord tenant board for compensation for damage to the property. Now what we have to do is we have to file it with Superior Court. Then we have another order that we can now is basically put a notice to the owners, a notice to the employer to say every single time that you pay Jay, a fraction goes to us. So it's a process. A lawyer or paralegal can certainly help you with that.
Excellent. Thank you so much. This was actually one of those questions that I had in mind as well, but thank you. We have quite a few great questions. One of our members, Ali, is asking that a property was sold. The tenant was given a month a property was taken over. The tenant was given a month for them moving out. The buyer then decided to demolish after a couple of months and decided decided to build a house. Can the tenant come back and ask for 3 months, or decided to build or renovate the house? Can they come back and ask for 3 months, or would this come back as giving in to all in bad faith?
It could be bad faith.
So basically, the damage is not here 1 month and 3 months. It's just basically that you didn't tell the truth.
Yes, it's like if you're moving, that's very dangerous, because what if you're moving in and they decide to rent it out now? They can get in trouble for that.
I see.
Yeah, that could be. And if it's a corporation, how much? $250,000 plus expenses plus the admin fee. That's problematic. How you could get around it is that, oh no, we're just demolishing it and we're moving into it. You could kind of say that, like, oops, mea culpa, I didn't realize, but that can be problematic if they're putting it up for rent afterwards, big time.
Yeah. No, thank you very much. And one of our members is also asking a question. Sia is asking, if we buy a property where the tenant has not paid the rent for the last several months, is it easier for the seller to remove the tenant or for the buyer? So
Okay.
basically, if you have a delinquent tenant and there's going to be a transaction, who should take this on? Should the seller be the brave one, the buyer be the brave one and say, don't worry about it, give me a discount, I'll take care of it? Or is the seller in a better position to take that on?
I like that negotiations. The buyer's taking that on, they better get a discount because it's big money. Okay, so Sia, I'm going to assume a couple of things. I'm going to assume that a notice has been given that the buyer wants to move into the place, okay? Now, if that's the case, it's so much easier for the seller to just boom, do it, because it shortens the timelines. Here's why. So if a tenant is going to say, a purchaser says, okay, I own it now, I'm the landlord now. So let's say October 1, we close. Now, as the new purchaser, I now have to give them notice. The notice has to be 60 days. I have to wait until the end of the term. It's a mess. Rather, it closes October 1. The landlord gives notice 60 days prior to October 1. And so on October 1, me as a purchaser has a clean place to move into, like a totally vacant place to move into. Do you see the difference? If I do it as a purchaser, it's 60 days after, like the new owner, 60 days after the October 1, the day the title transfers, versus if the landlord does it, it can be done October 1, I got a brand new place, I don't have to deal with the tenant. Almost always have the seller do it.
Yeah.
Now, a couple of things to pay attention to, though. If you're talking about a purchaser who is not moving in, have the seller evict them in that instance as well. Now, a couple of caveats. The seller's going to have to give proper notice. They're going to have to make sure the tenant gets the opportunity to repay the rent. There are notice requirements that still apply here, right? So make sure that occurs as well. I find very often, and this is so important to do, as a purchaser, if you intend to have the current tenant stay at the property, I strongly recommend that during the closing, you engage with the lawyer. The lawyer obtains something called a tenant estoppel certificate from the tenant, and that basically confirms that what the landlord, the current landlord, is telling you. The seller is telling you, yes, my tenant paid $100 a square foot, for example, etc. I see this happen a lot, where landlords pretend as if there are no arrears. No, there's no arrears. No, everything's fine. I don't owe any money to the tenant. The tenant doesn't owe me any money. Please buy the property. And then when you buy the property, you realize the tenant's saying, well, no, I don't pay $100 a square foot. I pay $5. What are you talking about? And then you have a whole disaster. So instead, what you get is something called a tenant estoppel certificate. A tenant estoppel certificate is effectively a legal document that the tenant signs, confirming that they pay $100 a square foot. Landlord doesn't owe them money. The tenant doesn't owe the landlord any money. There are no board applications from the tenant against the landlord, because those applications, you, the new purchaser, will be responsible for. And that document prevents the tenant from, after you close, saying anything to the contrary. That's what's in that document. So very important to do as well. Hopefully, Sia, that answers your question.
Well, I think it was very clear, and if there are any further comments, they can make it. Ali was basically mentioning, sort of in the other question that we asked, was the deal was not, when they gave a month rent for someone to leave. He's saying that the deal is not closed yet, so we actually have a chance to properly disclose it. So we can actually, I was asking if we could just do the 3 months for major renovation and give them 3 months, and would that make it right?
I would actually suggest moving in and then doing the renovations in a way that they can, well, I guess they want to demolish it. If I could have Ali reach out to me, I'd like to sort of rethink that one as well, because there could be some strategies there that are a bit more beneficial.
No, I understand that and very much appreciate that. If you don't mind, I wanted to ask another question.
Sure.
A landlord has promised to give vacant possession what is the role of seller in this situation?
So, assuming the seller is the landlord then has to provide the N12. And it's incumbent upon them to do so. If they fail to do so, that is a breach of the agreement of purchase and sale. The purchaser can sue.
Mm-hmm.
I actually just know a case, a friend of mine, I don't do this type of litigation, so if you do need help, I have a wonderful lawyer who does a lot of this. And I know he was representing, the seller. The buyers sued, and it cost the seller thousands of dollars.
Mm-hmm. So it's basically, I'm sorry, I missed a portion of it, but I don't think it wouldn't change the answer. But the portion of the question that I missed was that the property basically must be listed for sale. The tenant is in the basement, changes his mind, and decides not to leave once the deal is firmed up, although they had agreed with the sale. So basically, the landlord had promised to give vacant possession. What is the role of the seller in this situation? So pretty much what you mentioned covers it, but still, it's the tenant of the seller. The buyer, if the buyer was promised the vacant possession, I took it as, well, he's owed a vacant possession. And if it's not done, then the seller should have made sure that the proper forms are filled, proper notices are given, and things are going according to plan.
I think her question is, and I don't have a name, so I say your name, but I don't have it there. Real estate ownership. The property must be listed for sale. So if this is an instance in which the current landlord and the tenant have agreed for the tenant to go, and the property has yet to be listed, there's no agreement of purchase and sale, then in that situation, make sure the following has happened. Number one, you either signed an N11, right? Basically, that is, no matter the circumstances, I agree to leave, I'm out, even if there's no one buying the property as of yet. So make sure an N11 is signed. If an N11 is signed, the landlord can then take that to the landlord and tenant board, get a hearing, get an order for eviction, and then enforce the order for eviction once the eviction ban is lifted. Remember, there's an eviction ban right now in Ontario. Let me tell you, it's a process. That could be months from now. So you may be better off just trying to compensate the tenant, or what you can do as a landlord who wants to sell the place, but the tenant won't go anywhere, is say that the tenant won't go anywhere, or say that you'll at the very least give an N12, but you're not guaranteeing vacant possession.
Also, I received another question with regards to the commercial real estate.
Okay.
So basically, for commercial real estate, we had this situation: if they were in non-payment for 15 days, then the landlord could come and take possession. Is that completely out?
That's a big question. That maybe I'll come back for part 2 for the commercial sector, because the commercial sector, it could be out if the current ban would apply to them. So they actually could be, that could be not permissible.
Okay.
So I forget, I think Bill 190, I forget, Bill 190 something, basically says that if the tenant could have applied for the CERB programs, or the rent sector programs, and the landlord has not helped facilitate that, then the eviction ban is not, or the eviction is not permitted. Okay. There's a lot more detail there. I'm happy to discuss that during another presentation, because that's a very good question.
Be very much. I basically now from all of our basically social media, I asked all the questions. If there are any other questions, I encourage our members to reach out. We share the videos of our talk on the PICRA website as well. And one thing I wanted to mention is that Natalka comes very highly recommended from some of the biggest landlords that that we deal with on daily or weekly basis at least. and her specialty and her firm's specialty covers services to realtors. The firm is called Groundworks. It covers services to realtors, to landlord investors, and to large tenants. So please check out the website, take the contact, and if there are any questions, do reach out. I think after today's presentation, it is further highlighted in this environment to be well advised when you're dealing with contract that has a tenancy element to it, whether it's an agreement of purchase and sale where someone has to leave and give vacant possession, or is it simply a lease agreement one way or the other. As a lawyer and Osgood Hall graduate, I also am a graduate of Schulich. It's a pleasure to have you, and thank you so much for giving us your time. And we're looking forward to seeing you further in additional discussion and use your knowledge that way. Thank you again.
My
And
pleasure.
on behalf of PICRA, I would like to extend our thank you to you.
My absolute pleasure. Thank you for including me. It was a wonderful conversation, great questions. And if there's anything that you guys need, you can go through PICRA. I think that everyone has my information there. Arash, yourself as well. Happy to connect. Have a wonderful day. Be safe, be well, be healthy.
Thank you very much, Natalka.
Thank you. Bye now.
Bye.